Is that correct? Thank you. We are now live streaming. Thank you very much, everyone, for joining us here today for the Housing and Real Property Subcommittee. Correct. Today is March. We are now live streaming. Thank you very much, everyone, for joining us here today. All right. So someone is on YouTube. And
okay, it's Shirley. So Shirley, the YouTube opened up. You need to close the YouTube video. Otherwise, just mute yourself and I can come up and show you. Shirley, so the YouTube opened up. You need to close the YouTube video. Okay, I just muted her for now and I'll show her.
Sorry I'm late, Mr. Chairman.
What are you, from Canada? Sorry?
Yeah, yeah.
Canadian?
I'm the neutral UN observer.
Well, after this floor fight, we're going to start needing them.
Cancer.
Well, just things
all righty.
Not over just 2 weeks.
Delegate rival.
Here.
No, please mute if you're going to have people talking is all I'm saying.
Oh, you're right. I probably should do that.
Unless who wants to know your secret plan.
All right, ladies and gentlemen, we're going to get started. We only have an hour. Trish, we only have an hour. Is that correct?
Yes.
Yes.
Okay. We're going to start, ladies and gentlemen, with HB 50. HB 50 is a bill by Delegate Stewart.
Move favorable. I mean, we passed this bill last year.
131 to 0, I think it was.
Yep.
All right. Oops. So we have a favorable motion by our friendly chairman.
Can we be reminded of what the bill is, or the title at least?
Good thinking. Good thinking.
Did you?
Somebody needs to get off of YouTube or mute themselves. Something's going on here.
All right. So HB 50, ladies and gentlemen, all of you were sent out the agenda earlier. I assume that you had taken a look at it. HB 50 is a landlord and tenant residential leases, tenant right to protections. And in this bill, it's the first part of the bill speaks to what they refer to as RUBS. RUBS is an acronym for ratio utility billing systems. And in the RUBS system, the landlord is in this bill is to provide the tenant with documentation on how the utility bill to the tenant was calculated in the RUBS ratio utility billing system scenario. That's what the first part of the bill does, which means RUBS. And the second part of the bill talks about tenant organizations and meetings within the tenant's structure of the building so that tenant organizations can meet. And the third part of the bill talks about peace orders and sexual offenders and those kinds of things in terms of release of lease. Matthew, can you expand upon any portion of HB 50 that I did not touch upon, please?
Sure. There's one other, I guess, as noted in the hearing, the bill can be broken down to do 4 things. Delegate Holmes touched on 3 of them. The one that I missed was the bill would require a statement of costs when a landlord withholds portions of a security deposit to include, where practicable, supporting documentation. So bills, invoices, and receipts that identify the materials and services provided. Just to expand a little bit on the protective order portion, there's current state law with regard to termination of a lease for a victim of domestic violence or sexual assault. This would add a ability to terminate a lease for victims of stalking as well, in using methods consistent with current law for terminating that lease, and also providing a third option based on a report by a qualified third party, which is defined in the bill.
And I would remind the members of the subcommittee that this bill, HB 744 in 2020, had a floor vote of 131-0. Currently, we have a motion favorable and we have a second. I'm sorry, go ahead, Matthew. Go ahead, Matthew. Go ahead, Matthew.
Just to note, there is one sponsor amendment I'd like to discuss.
Oh, is there?
Yes, it's, and you should have received it for.
Oh, yes, I'm so sorry, Matthew. You are correct. You are correct.
That would be HB 50, or yes, HB 50-443828-1.
Right.
The first portion of the amendment is technical. Amendment number 2, this is specific, both provisions here, the changes on 4 and 5 are specific to the RUBS portion of the bill. The first one would require that any information that's provided by the landlord, it's on page 4, information regarding billing, including meter reading dates, billing dates, and due dates for a utility would be provided where practicable. For some discussion about the ability to really know when meter readings occur. Next change would be on page 5 at the top. The bill as it was written has a provision about local laws that are comparable in subject matter to the section specific to RUBS, superseding the provisions of this section. And this makes it clear that a local law or ordinance would supersede to the extent that the local law or ordinance is more stringent or provides stronger protections or broader applicability than the RUBS.
That's pretty typical amongst all of the local ordinances throughout all statutes in the state.
Right.
Yes, and the final change was something I noticed when going through the bill. It was adopted by the sponsor. Pardon me, page 11 of the bill.
Yeah. Page 11, line 4.
That is correct. And that was that the two conditions here were supposed to be, if the tenant vacates the lease premises earlier than the 30-day period that they're allowed after providing written notice and fails to provide a subsequent notice that they've vacated the property, thus allowing the landlord to know that the property is vacant and can begin the process of getting it back on the market, the tenant can charge, or the landlord can charge rent for the full 30-day period. Now, one of the changes under the bill is that if this second notice is provided after vacating within the 30-month window, after a victim of stalking, a victim of domestic violence, or a victim of sexual assault vacates in that 30-day window, they're only liable for the portion of the month that they use, the portion of that 30-day month. So if they leave after 10 days, they're only paying for 10 days worth of rent, but they have to provide notice such that the landlord would know that the property is vacant. And this would say that if they fail to provide that notice and the landlord wouldn't know, they could charge for the full 30-day month, but only up to the 30-day period.
Right.
This was how the bill was intended to work last year. It was a drafting error. And this simply corrects that drafting.
Let me get a motion on the amendment, please.
Move favorable.
Second, and there's a second. We have a motion favorable and a second. Any discussion on the amendment, Delegate Terrassa?
I just want to make sure that, so the whole thing is a sponsor amendment, or is part of this somebody else's amendment?
The entire amendment that we just went through is part of the sponsor's amendment.
Yes, that is correct. And the sponsor adopted some of the amendments that were offered by parties who testified on the bill.
Okay, but everything there is something that the sponsor was okay with.
Correct.
That is correct.
Okay, that's fine.
And by the sound of it, it sounds like the property owners are fine with it too. Is that correct, Aaron?
Well, Mr. Chairman, thank you. We still have some concerns. The sponsor was kind enough to accept some of our amendments, but we do have some concerns about the where practicable language, particularly relating, of course, to Baltimore City and its water billing issues. So we want some clarity on that. But with respect to the RUBS bill itself, we did urge the sponsor to provide that the tenant must request in writing a copy of that voluminous bill that's part of the RUBS product. So those are some of the specifics that we still have some lingering concerns about, Mr. Chairman.
And we can probably address those.
Does it
next
matter if
year's
it's
bill.
blue or black?
Doesn't matter. Sometimes it's neat when they're
Ann, mute yourself.
their hands.
And you need to mute yourself.
I'm sorry.
All right, any additional discussions on the amendments? Ladies and gentlemen, we have a motion and a second on the amendments. All in favor of the amendment signify by saying aye.
Aye.
Already had discussion on the amendments. Is that correct? All in favor of the amendment signify by saying aye.
Aye.
All opposed to the amendments, raise your hand, please, or say aye or something. No opposition on the amendments. We are now on the bill as amended. Do I have a
Move
motion?
favorable.
Is there a second on discussion on the bill as amended? Seeing none,
Chairman, what bill are we on?
5-0.
Just 50, okay. I didn't see any opposition in the testimony for that, but it sounded like there was some opposition on some folks who were on the call. Is that correct?
Not necessarily opposition, some suggested amendments.
Okay.
We have a motion and a second on the bill as amended. All in favor of the bill as amended signify by saying aye.
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 Any opposition?
Me, I'm opposed.
Neil Pear is opposed. Any abstentions on HB 5-0? HB 5-0 as amended passes. We will now go to HB 104. HB 104 is a bill that is sponsored by Delegate Stewart, and HB 104 is another landlord tenant bill, non-renewable of lease, and it's referencing notice requirements.
Mr. Chairman,
Sir,
move favorable.
Oh,
we have a motion favorable. Is there a second? We have motion favorable and second. Is there any discussion on HB 104?
yes.
Delegate Perry.
This bill really seems to harm landlords and people who are trying to, maybe you have one or two houses. I mean, how can you even make it work with this kind of bill?
Can I respond to that?
The question is, how can you work with it? Is that what you're saying, Neil? I'm not quite sure I understand.
I mean, if you can't maintain your own property and be able to make a profit on it, if you're losing money every single month, you're just gonna have to leave the state, go somewhere else.
Delegate Barve?
I don't believe the property owners oppose this bill.
I got calls on this one to please oppose it. I mean, and there is unfavorable right here by Bill Castelli and by Lori Graff.
Okay, well, let me, I guess I was misremembering it. I think the multi-housing people were not opposed, so
Yeah,
I correct my statement.
this bill had a lot of opposition.
Well, the multi-housing group had some suggested amendments to the bill. And the suggested amendments to the bill, and I'd like to discuss that if you could, please. The suggested amendments to the bill, first off, they suggested, one of the things was in the bill language, it talks about expiration of lease of the current year. And they wanted to strike out that language of the current year. And that's on, I believe it's on page 4 in 2 locations, and I think that's it. Aaron, if you could, can you expand upon your desire to strike that language of the current year, which I think kind of makes sense as well, but go ahead.
Yeah, so we don't think it's needed. I mean, it's more of a technical amendment because it doesn't seem to make sense the current year versus expiration of the current year versus expiration of the tenancy. It seems as if the current year doesn't sort of fit into the language of the bill. And so, you know, we didn't think it made sense. And then there's other parts of the bill, for instance, that don't speak to current year. For instance, lines 4 through 6, if I'm not mistaken. So we just thought to clear it up, strike current year. We had less concern about that than the 2 additional amendments that we've also offered.
Well, let's talk about this one first.
Yes, sir.
The current year, as discussed by Mr. Greenfield, that language of the current year is in 2 parts of the bill, but as Mr. Greenfield indicated, it is not in previous portions of the bill. And I think what Mr. Greenfield is attempting to do is to make the entire bill consistent in language all the way through. Matthew, I'm sorry, go ahead.
I was going to say, do we have a written amendment to that effect?
The amendment that's being discussed is in the MMHA testimony.
But answer your question, Mr. Chairman, no.
One thing I will note about this and is that the language being referenced here is current law. In this, using this wording, all that the bill did with respect to that section was repeal and reenact it in a more legible manner. And so what I just using the bill, the draft of the bill, refer to lines 31 through 38 on page 3. And starting in line 33, you'll see, in case of tenancies from year to year, including tobacco farm tenancies, notice in writing shall be given 3 months before the expiration of the current year of the tenancy, except that in cases of all other farm tenancies, and there's a little bit more that's provided.
And that is in current language. Current language does specifically state that those words of the current year.
And I want to just
Can
the
you
intent.
say, I'm sorry, can you say again where you are? Because I missed the page reference on 104.
Absolutely, Delegate Terrassa. That would be page 3. And I actually started reading in line 33.
Okay, thank you.
Yeah. And so just to remind the subcommittee, the bill is not intended to alter anything with regard to notice requirements for tenancies for year to year farm tenancies. The change would be tenancies week to week, or excuse me. Actually, let me refer to the fiscal note, which I will say lays out nicely what the new periods would be on page 2. So for a landlord tenant having a written lease for a stated term in excess of 1 week, or a tenancy from month to month, and the tenant has resided on the same property continuously for 2 years or less, the required period of notice would be 2 months. Same conditions, except that the tenant is residing on the property for more than 2 years, would be 3 months. And then the other, I guess there is one other change. Landlord tenant does not have a written lease for a periodic term of week to week. It'd be 3-week notice. The other notice periods are consistent with current law.
Delegate
Chairman,
Terrassa.
I have to check out here for the last 2 or 3 minutes. I'll be back. So don't
Okay.
keep up.
Delegate Terrassa.
So Matt, is your point that you don't think we need an amendment to do that? We're
Well,
not changing anything, so we should just move,
So essentially, yes. My point is just that the change being offered here, while it may very well be technical, and I'm not, it's just not,
Delegate Terrassa. Delegate
section.
Terrassa. His answer is yes.
Yes.
okay, so I guess my feeling on it would be we should just move forward, especially if this hasn't been discussed with a sponsor. I'm not comfortable in changing it in a way that wouldn't be clear if it would make a change. So I'd rather just move forward.
And therefore, I assume that based upon the discussion of the subcommittee, that amendment is not being requested or suggested. Moving on to the second part. Yes, ma'am. Delegate Healy.
Unmute. Thank you. I'm sorry. I'm just concerned about, does this affect like single family homes that people might be renting out and they're like and after a year they go to month, then they want the property back and they have to wait an extra month? Is that that's going on?
Yep.
It would be included.
Single family homes would be impacted under this bill. The provisions in the law are notice provisions. They're not particular to any certain type of dwelling unit. That dwelling unit's not defined or the property type's not defined. I will note that there are counties that already have a 60-day notice period.
So this would make it, if you renting, like give a year lease and then after that it goes to month, when it gets to the month, what is the notice requirement in the bill?
60.
It would, well, it depends on how long the party has lived there. If they've lived there, it would be 60 if they've lived, if the tenants lived in the property for
1 year
or less, and 3 months for more than 2 years.
Yeah, right.
Okay. I have concerns about that. Thank you.
And the concern that MMHA is indicating is precisely what you're saying about once you go to month, it's talking about the current year.
That's right.
That's their concern. Is that now we're talking about the expiration or the tenancy termination in the current year. That's what that's what their concern is. What if it happens in March, September? That's what their concern is. And
okay.
And as indicated by Matthew, that term, however, as indicated by Matthew, the term, the current year is in existing language. Is in existing language. So, is it confusing? If it was there before. And everyone seemed to do okay, I guess. Maybe they didn't, but if it was confusing, it was there before. You follow what I'm saying?
But right, okay, but in current law, correct me if I'm wrong, if you're on a month to month, at the end of the month, that's it. I mean, at any time, you don't get these extra 2-3 months.
That's correct. And that's the main purpose of the bill. In current law, after your 12 month, in a 12-month lease, after your 12 months have expired, well, prior to your 12 months expiring, the landlord has to give you a 30-day notice to terminate the lease. Or if the landlord does not give you a notice for whatever reason, you now are automatically on a month-to-month lease.
Right.
That's
current law.
That's current law. What the bill does is it requires, in a termination of a lease, it requires notification of terminating the lease. 30 days if it's a 1-year lease, 60 days if it's a 2-year lease. I believe that's correct, Matthew. And there's a 90-day provision in there too, which I can't recall off the top of my head.
I think that if you've lived there for 2 years, the 90 days applies.
Yeah, for more than 2 years, the 90 days.
More than 2 years. Okay,
I would just note that currently in law, in monthly or weekly tenancies, a notice in writing of 1 month or 1 week, as the case may be, shall be so given. So if you are month to month, you still would require a 30-day note, a 1 month notice.
Okay.
In a month to month lease. It's not as if at the end of that month, everything just ends. There is a notice period provided.
Okay.
Oh. This is about how long that notice period should be. The bill doesn't change when or whether or not notice is provided, it's focused solely on the length of that notice that's required.
So may I ask a question?
Yes.
Matt, so if we pass this bill as it's written currently, and a person's on month to month, will they require a 60-day notice?
If there's 2-year lease, yes.
Yes. Yes, they would require it. Well, it depends again as to whether it's a 60 or 90-day notice, but yes, they would require the notice period.
Right. They would.
The 60-day or the 90.
If you're in for 2 years.
That's correct. So, and again, what I want to emphasize, like I said at the very beginning, we did pass this out previously.
This bill is new for this year. It's not been a prior.
I'm sorry. I was talking about 50. I'm sorry. You're right. I'm sorry. Thank you, Matt, for keeping me straight. Thank you, Matthew. This is a new bill. Right. I was thinking about 50. So what I would like to do, ladies and gentlemen, so we can move forward, there was that one amendment suggested by MMHA. It was not suggested or requested by the sponsor of the bill. All right. The other amendment that was suggested by Mr. Greenfield and MMHA and others was in reference to the frames suggested in the latter portion of the bill, talking about a month versus days. And this, Matthew, if you could discuss that portion of the bill as well. 30 in some leases. In some leases, there is a definition of a month put in the lease. Month means 30 days.
Yes.
Maybe some leases don't have that in there, which is one of the reasons why MMHA is suggesting that instead of saying a month or saying 2 months, they should be 30 days for 1 month and 60 days for 2 months and 90 days for 3 months, having the time frame defined in the bill as opposed to just having the definition assumed. That's what the other part of the bill is talking about. Matthew, can you pick it up from there?
Yes, no, that's a very nice restatement of what the issue was. I will note that other places in the Real Property Code, when defining a notice period, they would use 30 days or 60 days when the goal is a month or 2 months. Again, I will just note that it appears and that a lot of the use of month or 2 months versus saying 30 or 60 days.
I am at my desk and I'm Zooming.
You're also being overheard by everybody.
Shirley, can you mute Barry, please? Can you mute Barry? Thank you.
Well, just to conclude, I think the reason why month was used instead of saying a 30-day period or 60-day period, whatever would be the case, was that in current law, references are to 1 month or 1 week or 3 months with regard to tenancies for year to year, farm tenancies. So this was just to, I imagine, to keep things consistent with how things are in current law.
So current law speaks of months and not days is what you're saying. Is that correct, Matthew?
Yes, and I would just refer back to page 3, the lines 31 through line 3 on the top of page 4. You can see, again, the use of month and not 30 days. If that were something the subcommittee wished to do, there are probably a number of other places where that change would need to be made from 30 days to, or from 1 month to 30 days.
All right, what I'm going to suggest, ladies and gentlemen, let me hear from Mr. Greenfield first.
Thank you, Mr. Chairman. Just a couple things. We did offer these amendments to Delegate Stewart. He did not decline to take them. He just said he would consider them. So there's been no sort of response or feedback yet back from Delegate Stewart. More importantly, the reason why we indicate that this is days is because it's more consistent. It's actually consistent and precise with the local ordinances. So you have Montgomery County and Baltimore City that already provide for 60-day notice of intent to terminate tenancy. All we're doing is trying to make that consistent with the local ordinances. That's really the impact of these amendments.
Okay, all right. To be honest with the subcommittee, Mr. Delegate Terrassa. Delegate Terrassa.
Yes, I just realized I was not. Yeah, I don't know where you're headed with this, but I'm okay either way. Like, I don't think that's a big deal either way. Like, I think if we want to do it, that's fine. I don't think we should hold it for that.
Well, it is not my intention to hold this bill for any reason.
Okay, okay, good. I don't have a.
I do.
Okay, good. I'm ready. Like, I'm okay with like 30 days or a month. Like, I think it's fine.
I particularly
Either way.
like the days scenario versus the month or 2 month scenario. However, if I think we should move this bill, Mr. Chairman.
Yeah, I want to move the amendment that refers to 60 and 90 days. I think it makes sense. I mean, one of the things that drives me crazy about the landlord-tenant laws is we have so many inconsistencies where sometimes it's calendar days and business days and all that. And I think that having 60, 90 days makes sense. I'd like to move that.
Is there a second?
Second.
Any additional discussion on the amendment offered by MMHA specifying days rather than months? I would like, in terms of discussion purposes, there will have to be some adjustments in other portions of the bill just to make sure we're current. And we'll have Matthew take care of that part. Is that correct, Matthew?
I will take care of that and have a reprint out for the voting session for sure.
Wonderful. The amendment has been motioned and seconded. In additional discussion, seeing none, all in favor of the amendment signify by saying aye.
Aye.
All opposed, say no.
Aye.
Any abstentions? I apologize for the pause. I hit the wrong button somewhere. The amendment passes on the bill as amended. Is there a motion?
Motion.
The second on the bill is
Second.
Bill has been motioned, favorable and seconded. Is any discussion on the bill as amended on HB 104?
I have a question on it before we vote.
Okay.
What about the case where the tenant has not paid the rent? How does that affect the landlord in that case?
This particular language doesn't touch the failure to pay rent statute.
No, it doesn't.
So different statute, different set of rules.
Right. This has no language relevant to that topic.
Okay.
This has only to do with termination of a lease.
Notices. Yes. So we have a motion favorable on the bill as amended. We have a second. Any additional discussion? Seeing none, all in favor of HB 104 as amended signify by saying aye.
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 All opposed, say no.
Opposed?
No,
And just so you know, I just don't think it's fair if it's month by month that the person who's renting can get out within a month, but the landlord has to give like 2 months. That just doesn't make sense to me.
So Parrott and Wyville, is that all the opposition? And Ciliberti,
Thank you.
any abstentions?
That's thick.
Seeing none, HB 104 passes as amended. We will now go to HB. We're gonna skip HB 499 because we're running out of time, ladies and gentlemen. We're gonna skip HB 499. We're gonna now go to HB 560. HB 560, ladies and gentlemen, is a bill by Delegate Fennell, and it's referring to discrimination in housing, re-entry into society status. The main crux of this bill, ladies and gentlemen, is adding another special class to prohibited discrimination in housing. This would add a reentry status, much like gender identification, familial status, etc., to this particular bill. We did get a letter from the State of Maryland Commission of Civil Rights, who, and all of us received that. They were not necessarily looking favorable upon this particular piece of legislation. They had some concerns about it, I should put it that way. I see Delegate Barvey's hand is up.
Move unfavorable.
There's a motion unfavorable and there's a second. Is there any discussion on the unfavorable on 560? Seeing no discussion on HB 560, all in favor of the unfavorable signify by saying aye.
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 All opposed to the unfavorable, raise your hand. Motion, I'm sorry, Delegate Healy. No, okay, there's no, wait a minute, come on, Alan. All of those voting against the unfavorable, raise your hand. No one. Okay, so it's unanimous that HB 560 is unfavorable report from the subcommittee. Thank you, ladies and gentlemen. We will now go to HB 574. HB 574 is a Montgomery County bill, and this bill is affectionately referred to as just cause. This bill is a just cause eviction bill. The bill requires several steps for a landlord to evict a tenant. This is a very new process. If this bill takes place, Montgomery County will be the outlier. I see Chairman Barvey's hand is up first, and then we'll go.
Well, why don't you go to David first, and then
DFH.
Is this the same bill that we've had for, I think, 4 years in a row?
Yeah.
Okay, move on. To
There's an unfavorable motion on the floor. Is there a second for the unfavorable?
Second.
There's a second. Let's have any discussion on the unfavorable motion?
Yeah, can I speak on this?
Yes, indeed.
Yeah, I am very concerned about what this would do to the private sector market, what this bill would do. We have a case of a market failure in Montgomery County. Because of rent control in Tacoma Park, no new apartment buildings have been built there since 1983. And that's not good for renters. Rent has gone up faster in Tacoma Park than in the rest of Montgomery County because the non-regulated units can hike up their rates. They don't have any competition. My concern is that if we were to basically force a landlord to go into court to not renew a contract, the result would be that, well, first of all, let me just say in my building, there was a guy who was smoking marijuana and smoking like a chimney, and a bunch of us confronted management to get rid of him. We wanted him to be evicted. We wanted him to take him to court, and management said, well, that'll cost us $10,000, but his lease runs up in 5 months, so we just won't renew his lease. And one of the other people were angry that they weren't spending that $8,000, $9,000, $10,000 to get rid of him. But to me, I thought that just not renewing the lease made a lot of sense because there were a lot of amenities that that we needed to have put into the building, like electric car charging, for example. And the more money the landlord is forced to spend on situations like this, the less money there is available for other amenities like changing the rugs or whatever. And so, and I'll just finally say in Montgomery County, evictions are 0.6%. I just think this is a solution in search of a problem that doesn't really exist, at least in Montgomery County pre-COVID. Now we're going to have a lot of bills having to do with COVID, which I support, and I supported the 60-day and 90-day notice bill, which I think covers this issue area. So I'll be voting against this bill.
We have a motion and a second. Any additional discussion on the unfavorable motion for HB 574? All in favor of the unfavorable signify by saying aye.
Aye.
All opposed to the unfavorable, raise your hand. Any abstentions? HB 574 will receive an unfavorable report from the subcommittee. Ladies and gentlemen, in light of time, I'm going to skip HB 861. However, Matthew, let me ask you a question on HB 861 before I skip it. Do we have the amendments ready for that one yet?
Yes, you do. They were part of the email that the members received last night.
Let's go back to HB 561 then, if we have time, after we take care of some other bills down in the calendar. Okay.
Sure.
All right. It's 1:13 at the present time, ladies and gentlemen, and we have to be back in committee at 1:30. Is that correct, Chairman Barbe?
Yep, that's what I said.
Okay. All right. So let us move now to HB 1201. HB 120. Pardon?
Mr. Chairman,
Sure.
I'd like to move unfavorable. I just don't, this is 1201.
1201. We have a motion motion unfavorable and a second on HB 1201. And a second by Delegate Healy. Any discussion on the unfavorable for HB 1201? All in favor of the unfavorable signify by saying aye.
Aye.
All opposed to the unfavorable, raise your hand. HB 1201 receives an unfavorable recommendation by the subcommittee. We will now go to HB 1218. This is a bill that is referencing estoppel certificates. Is there a suggestion by the subcommittee?
Well, I don't want to have to be the only person who moves unfavorable, Mr.
There's a motion unfavorable. Is there a
I motion
second?
unfavorable.
Any discussion on the unfavorable of HB 1218? Any discussion?
Can you read the title of the bill, Mr. Chairman?
Estoppel certificates, notice of receipt by landlord. Estoppel certificates, notice of receipt by landlord. That is the title of the bill, HB 1218. We have a unfavorable motion and a second on HB 1218. Is there any additional discussion? Seeing none, all in favor of the unfavorable signify by saying aye.
Aye.
Any opposition to the unfavorable? Any abstentions? Seeing none, HB 1218 receives an unfavorable from the subcommittee. We will now go to HB 1220. HB 1220 is cancellation of renewal of lease notification requirements. Any discussion or suggestions by the subcommittee? Delegate Parrott?
Move unfavorable.
There's a motion unfavorable. Is there a second?
Second.
There's a second. Any additional discussion on HB 1220? Seeing none, all in favor of the unfavorable on HB 1220 signify by saying aye.
Aye.
Any opposed? Any abstentions? HB 1220 receives an unfavorable report from the committee. We'll now go to HB 1273. HB 1273 is a bill that speaks to commercial lease addendum and liquidated damages. Is there any,
Well, I'm sorry, what's the bill number, Mr. Chairman?
HB 1273.
Move unfavorable.
There's a second on there's a second on the unfavorable for HB 1273. Any discussion?
Well, can you just say what that bill is? Because
I'm sorry.
Sorry, Mr. Chairman.
Go ahead.
Can you just say what that is? I'm having a little trouble because that wasn't apparently on, well, I don't have it on my list and I apologize. I must have missed that one. Can you just say what that bill is? I don't have any idea what it is.
It requires $1,000 in liquidated damages to be paid.
If
Or more.
Oh, for the lease?
Yeah.
Minimum,
Okay,
a minimum
that was
of
from
one,
the other day. Okay, I
a
got you.
minimum of $1,000.
Yes.
That's pretty much
1,000
it.
unless a greater amount's required.
On commercial leases.
Yeah.
Yeah, that's
Okay.
pretty much it. We have an
Thank you.
unfavorable motion and a second. Any additional discussion on HB 1273? All in favor of the unfavorable signify by saying aye.
Aye.
Any opposed to the unfavorable, raise your hand, please. Any abstentions? HB 1273 will receive an unfavorable report from the subcommittee. And now it is 1:17. Matthew, in your opinion, do we have a time frame left to go through the amendments on HB 861 between now and, we do need a little bit of time, between now, can we do this in 5 minutes, Matthew, you think?
But there's a substantial number of amendments, so if it's the subcommittee's intent to make a motion on the bill, probably not do it in 5 minutes, but you could certainly begin the discussion. The amendment was included in your packet. I'm
Okay,
happy to go through that.
Let's do this, ladies and gentlemen, and I'm gonna keep my eye on the clock, and I'm gonna give us a hard stop at 1:25. Okay, Matthew, if you could please start to go through the amendments on HB 861. Thank you, sir.
So just to start out, I will note that this was an amendment that was worked on by the sponsor with several of the stakeholders who were formerly unfavorable. And this, as I understand it, is a consensus piece. Unfortunately, I'm going to just speak kind of linearly as going through the amendment. So the first amendment would apply the provisions of the bill to residential leases only, would carve out commercial leases. And that's the change there is the change from subtitle 1 under Title 8 to subtitle 2. Unless otherwise provided, all of subtitle 2 applies only to residential leases. The next change would require that the reusable tenant screening report be prepared within the previous 30 days to be valid. And this is done by altering the definition of what a reusable tenant screening report is. Next, the amendments would alter the required elements of a reusable tenant screening report. Those, I unfortunately don't have, hold on. Just ask your indulgence for 1 second.
Mm-hmm.
Hey, Mr. Chairman, could I ask a question of all the lobbyists who are in the room right now?
Sure, and yes, indeed, all the stakeholders.
Have any of you not seen the amendments?
No, we've seen them all.
We've seen them all. We worked for quite a few hours with the sponsor. And
Are you okay with it? Is there any lobbyist here, property owner, public justice, anybody opposed to these amendments?
No one?
I have
No one?
some questions.
Everyone's singing Kumbaya?
But I mean, I'm not saying that we should vote for them sight unseen because of that, but I think that informs the conversation because I think we are running out of time, but it's a good tool to have.
Bill?
Oh, I was just saying, not to the amendments. No.
Okay.
Okay.
Well, it's 1:20 now. This is what I would like to do, ladies and gentlemen, of the subcommittee. I'm going to call another meeting. Let me ask this question, Mr. Chair. Today, how many bills do we have today, Mr. Chair?
Actually, not that many. We have 4 bills, and we have, I think, a total of 12 or 15 people testifying. It's not a super.
Okay.
So 14 witnesses.
So we could, in effect, have another opportunity this evening to come back and discuss this.
I would think so, yeah.
That's what I would like to do. Ladies and gentlemen of the Housing and Real Property Subcommittee, I would encourage you to look at the amendments for HB 861, and then I will call for another subcommittee meeting after bill hearings today. Delegate Terrasa?
Can you give us a few minutes after our ENT hearing just to read over them, because some of us are paying attention to the ENT hearing, and
Sure.
it would be helpful to have time to look more closely at the amendments. I mean,
Sure.
maybe it may just be 10, 15 minutes, but at least a few minutes.
Not a problem whatsoever. Just like the chairman of our committee, I am the friendly, benevolent subcommittee chair leader. Delegate Lehman?
Yeah, thank you, Mr. Chairman. I was going to suggest the same thing. Look, I get the need to move things,
How do I get a hold of amendments?
but the breakneck speed is a little much for me.
I will do so. I'll hold on. I'll hold on till after the full committee meeting. and give us all an opportunity to read
Yeah,
through these.
I may or may not agree with what the lobbyists like in these amendments. So you know what?
I'll give us all an opportunity.
Yeah, we're going to discuss it. Thank you.
Yeah, but let me just explain, Mr. Chairman. I didn't ask those questions because I wanted to hurry up and pass it in 3 minutes. I just thought that it's a good thing to park in the back of your mind for the next meeting.
Yeah, and I wasn't trying to ram anything down anyone's throat either. I just know that we don't have time now to discuss it. And I agree with what everyone is saying. Take a break after bill hearings so we can have an opportunity to read all of these things and then come back and discuss them like we discuss, like we discussed amendments. We will discuss them until everyone is feeling good about it. At this particular point, it is 1:22.
I had a quick question.
I'm gonna go
Yes,
grab
sir.
one. Bye.
Has Matt sent over those amendments recently?
Yes,
Yes.
yes.
So, okay, so we'll have them in our inbox. All right, thank you.
Is any additional questions from the subcommittee? Seeing none, after we'll have another meeting on HB 861 after our committee hearings this afternoon, ladies and gentlemen. Thank you so very much.
Very good. Thank you.
All right. All right.